Graphene is a unique nanoscale form of carbon that is disrupting legacy materials, bringing step-change improvements in performance across a wide range of industrial and consumer applications. From energy storage and electronics to everyday materials, graphene enables products that are better, stronger, and lighter, while increasing durability and improving sustainability. Graphene is leading the era of new advanced materials.
The following is a presentation that was given as part of a 2-day virtual Graphene Investors Conference, hosted by the Graphene Council.
Yeah, thanks a lot, Terrence. We appreciate you allowing us to speak and to be part of this event. Definitely some great companies speaking, and I know there will be a lot more coming after us and tomorrow as well. We spoke to Terrence and wanted to give a talk on technology licensing, some tips, tricks, and tactics. Obviously, a lot of you got, most of the companies speaking today are Series B round companies, so they've been through a lot of the basics. So we're going to kind of assume you have a basic knowledge and then just kind of talk about some top line issues that we see that, people need to address and some things that maybe you hadn't thought of so far. So we're going to keep it at that level. This is just the typical disclaimer that we're not giving legal advice, just general information only, and that you should consult with a legal professional about any specific questions that you may have. And we're obviously available to talk to anybody after the presentation, but it is just general advice. This slide is just for Matt. Matt got a new photo, wanted everybody to see it, but he's a great attorney. He does a lot of the technology transaction and licensing agreements, also any kind of M&A on the IP side of things. So he's great on all these kind of agreements with third parties. I'm an intellectual property attorney as well, partner Duane Morris. My focus is more on the patent preparation and prosecution, and then strategy for all that to help build out the portfolio and protect your technology as you grow and kind of look at that whole landscape to make sure you're protecting what's commercially valuable to you and blocking your competitors. So planning for technology licensing, we're going to start out patents. One of the big things that, no matter how long we do it or how much we talk about it, comes into play is ownership of the patents. Definitely when you're going into doing a deal or when you're working with third parties, this is something that people trip up on. Also, one thing people don't talk about that often that I wanted to just kind of throw out there is some tactical patent filings, not just protecting exactly what you want to protect, but also some things that may help you strategically from a different perspective. And we'll get into that. Trade secrets, we talked about a lot of trade secrets. Alvin was talking about his with Graph Up. Obviously, Haley, who I met at another presentation and heard speak today at Mito. There's a lot of trade secrets going on with all the companies here today because of the nature of the technology. It's not something that's easily copied and designed. So it's something that's very easy to use as a trade secret. And the techniques of making these end materials can also be protected very nicely. One of the things that comes up sometimes is creating value with trade secrets. Yeah, you've got something that's a secret that may be of value to your competitors or to your customers, but how do you make sure that people know about it without knowing what it is? So I think that's an important feature, especially as you're looking to do these licensing deals and monetize it. I think this creating value strategy is very important. Patent ownership, the inventors own the invention in the US. It then has to be assigned to the company and the employer. So from that standpoint, some basics are, make sure your employee handbook talks about IP and the requirement to assign any IP that's created, within the scope of the employment. Also make sure in third-party agreements, no matter how trivial they may seem, that you've got your NDAs in place that we're just talking about, that Terrence and Alvin were just talking about. And then when you do development agreements, make sure that it's spelled out ahead of time who owns the IP that's going to be generated. Sometimes you'll have background IP and the other company will have background IP, but who owns what comes out of those developments? It's better to have that up front. It's a pain to negotiate sometimes, but it's much worse to litigate. Litigation always gets a lot more expensive than the negotiations up front. So, do that. Make sure you involve your counsel, because there are some things where it's important that you get specific. If you just assign a patent, it doesn't necessarily include the right to sue for past and current damages. It may include future damages, but those are some of the things that people don't always think about when they throw together these little agreements or run out and try to find some template online. So due diligence, like I said, when you come in and look at doing a deal, they're going to come in and look and make sure that you own the patents, that the ownership is correct. This isn't exactly a licensing agreement, but I think it's an interesting example where the due diligence on a patent ownership became very critical and wound up saving the client, tens of thousands, if not more, of dollars. So we had a client who received a cease and desist letter that included a draft complaint from a very well-known litigious non-practicing entity. The patent allegedly covered navigation of a website using thumbnail images, which, on its face, you're like, okay, we can easily invalidate that, but the cost of litigating to invalidate a patent or to file even an ex parte re-exam with the patent office, it gets very costly very quickly. So even a very trivially invalidated patent could cost you, hundreds of thousands of dollars to invalidate, or definitely tens of thousands. So we had a client who got this letter. They were very concerned, obviously, that they didn't want to have to pay ransom for something that, shouldn't have been patentable in the first place. And they also didn't want to litigate and take that risk. So during our initial due diligence, before we even started doing the full analysis of the patent, we did see that the patent had been asserted in several lawsuits and that they had been subsequently dismissed, which is very typical. You file a lawsuit, there's a settlement, and then the dismissal. So people had been fighting about this, it had gotten that far. So during our initial due diligence, we saw that there were 18 US inventors. We looked at the assignment database. There was an assignment from a French company to the US company, and then a US company to the actual company that was suing our client. The patent was about 15 years old. It had been filed about 15 years ago. So we looked and saw that gap. There's 18 US inventors. There's a French company that recorded an assignment from them, from the French company to a US company, but we didn't see anything from the inventors. So I told the client, I said, let's just stop here. We don't have to do any more analysis. Let's just send them a letter, ask them to prove that they own it. And if they do, then we'll get into all this other stuff. So we did, simple letter, we appreciate you. We respect intellectual property rights. We'd appreciate it if you can, we notice the chain of title has problems. Please send us the assignment and we'll be happy to talk to you going forward. Never heard from them. That was many, many, many years ago. The case basically got dropped. They lost interest, and we didn't even get to the point where they filed a lawsuit. The client was thrilled because they spent, very little money, a couple hours of time to do all that, and very happy client. So, that it's not specifically on point for licensing, but just to show you how critical that is and how critical paying attention to the ownership is. I think it's a great example. So now tactical patent filings. I think this is an interesting one. Filing to create prior art. It's something I think gets overlooked, especially with trade secrets. Sometimes you're filing a patent to get an enforceable patent that you can stop your competitors for. Sometimes you're just creating a portfolio so that if you get sued, you have things to counter sue with. And then sometimes, in this case, if you got a trade secret or you do a search and you're like, oh, this may not be patentable, this combination, we don't want to go after it, you can file an application that's just to create prior art for your competitors. So you basically look at what you're doing for your trade secret, you file a patent around it that kind of talks generally, but doesn't disclose what your secret sauce is. And it's just something to block your competitors, that if they ever try to file a patent on what you're doing, maybe this blocks them. So you're given enough detail to create an obstacle to your competitors trying to patent it, but you're not giving away your secret sauce. And then you can file a request for early publication, so it becomes prior art sooner. With early publication, it publishes approximately, 3.5 months, 3 to 4 months after the patent application is deemed complete. So once the patent office has received everything. I think it's a nice approach. It's also something we do people will do sometimes if they don't necessarily think what they're doing is patentable or what they were going to do is patentable, but they still want to block things. And, you can tailor how much effort you put into the application. But I think it's a nice thing to do to protect yourself, because prior practice of an invention, of your trade secret, is a defense to infringement. But it's better if the competitor never gets the patent to assert against you in the first place. So just another approach or another tactic that you might want to use. Another one is a filing that keeps your competitors guessing so they can't design around it. You can file the patent application with a non-publication request. And then the application only publishes, standard process is that at 18 months from the earliest filing date, you have a publication. If you do the non-publication request, it doesn't publish until you get a patent. So they can't really see what's going on. You can mark your products as patent pending, and your competitors can't try to design around it. There's a lot of reasons you might want to do this. The one caveat is, if you do a non-publication request, you can't foreign file, because that's part of a lot of the treaties that were parts of that allow you to claim priority. So you can't claim priority if you do the non-publication request. But it's a nice approach for different situations, but it definitely keeps your competitors guessing. And then, people always ask, well, why does it take so long? How do we get them filed faster? And 2 ways you can get prioritized examination. One is if you have an inventor who's over 65, you can file a petition to make special based on age, and that's free. If you can't do that, the other way for your foundational patents or your patents you're really excited to get, if it's really important to get a notice of allowance and an issued patent quickly, Track 1 allows you to do that. The fee is steep. It's $43.40 for undiscounted entities and $17.36 for small entity. They target final disposition within a year. Their statistics online say more like 6 to 8 months from the initial filing. So it's really good. The dispositions I've got on the right-hand side of this slide. You can see 61% result in a notice of allowance, 35 in a final rejection. So it could be a good way if you're looking. You need a specific patent in order to raise money. Your investors want to see it. This can be a really good way to do that. So prioritized examination. It's much better than what they used to do when I first started, or early in my career, where they actually made you submit an examination support document where you had to make your own rejections against yourself and explain how you overcame them. You had to do a specific search, and the background work you had to do just to file for prioritized examination was way more than this. So it's an interesting option. So we're going to turn to trade secrets. Obviously, I think this group knows a lot about them. It's information that has economic value because it's not generally known, and you've taken efforts to keep that information secret. The great thing about trade secrets is they extend until they're no longer trade secrets anymore, until they're not known. I have to, I'm not going to go into too much about the pros and cons versus patents, because I think a lot of you have an idea about that. The one kind of thing is it's an opportunity to talk about artificial intelligence. Definitely don't disclose information to artificial intelligence on your trade secrets. Most AI has terms and conditions that say they have a license to use this data as training data. So if you upload your confidential information, it could show up in someone else's search results as an answer to a question. So you definitely don't want that. Samsung had a big issue with that late in the middle of last year. Some companies banned it, but people are getting more wise to this, but it's just something to really be knowledgeable about or know that can be an issue. So just be cognizant of what AI you're uploading your information to if you do that, and that it's not going to be, a disclosure. Creating value, a lot of times people have these trade secrets and they don't know what to do. You know, they keep them a secret, but they also want to license them, or they have a secret, but they, you know, want to sell it. And I think a really great way to do that, make people aware of what your secret sauce is and what you can do, is by having a trademark. You know, it creates awareness and value to both consumers and, you know, acquirers or licensors who may want to be involved with that. So, you know, they're like, oh my gosh, you know, Mito makes a better product than any, you know, better graphene than anyone else. And so this tells them how, you know, it puts a name to that, whether it's your company name or if it's going to be Graph Up like Alvin was talking about. You know, it's a really great way to designate that you do have secret sauce and that what you're doing is special. So I do like, you know, if you have some products with it and some products without the trade secret, you know, use a trademark to distinguish that. I mean, there are definitely, you know, different ways people use to protect trade secrets. I had a brush with that with as an engineer years ago when I interviewed with Kraft Miracle Whip. Just an interesting story. They actually make the precursors in 3 different factories so that no one knows what all the precursors are, and then they ship them to a 4th facility where they actually combine them to make the Miracle Whip. So, you know, there's lots of creative ways. I think that's an interesting story. And Kevlar, you know, there are lots of examples. I think you guys get it. But I definitely push the trademark aspect to creating value for your trade secrets. And now we'll turn it over to Matt to discuss the licensing aspect, now that you have the information to protect.
Yeah, sure. Thanks, Greg. So as Greg mentioned, Greg gave a great kind of primer here on the different types of intellectual property that you might be thinking about, and kind of the strategy behind kind of getting your IP kind of set and a strategy there for prosecution for generating value there. And so a lot of times where I come in is after that process where one party or another has IP that they're licensing to another, and then what I do is technology transactions, licensing, any kind of commercial transaction that touches IP or IT. So what I'm going to talk about is a lot of what we think about when we put an IP license agreement together, and kind of just step through kind of a longer checklist of things that we think about, things that we advise on. Every deal that we put together is different. There's going to be, of course, different commercial terms and all of that, which I largely don't get into. I really kind of defer to the businesses as far as putting the commercial deal terms together. But there's a lot of things to consider as far as legal terms and just making sure that parties are thinking about things that they really should be as they're putting a deal together. So starting with kind of the scope of what is being licensed, which seems kind of like an obvious one, but really there are a couple of things to really tease out. As Greg was just saying, you know, sometimes there's a combination of different intellectual property assets that you're putting together in a package for a license. As a licensor, and a lot of this presentation is going to come from the perspective of the licensor and kind of what the best things to be thinking about from the licensor's perspective. But from a licensor's perspective, it is valuable, as Greg said, to have you know, not just maybe not just patents, a license to patents, but license to patents and know-how or confidential information. So you're not just saying, hey, you can use my patent, but here you're actually providing some additional information, some additional materials, and to get the licensee kind of up and going. That's more valuable, and so that kind of combination can generate more value for the licensor. Trademarks are another great kind of value adder. I like to talk about trademarks as kind of a multiplier, like a force multiplier or a value add. Just whenever you have a mark around something, it kind of, you know, speaks for it, and that's kind of the purpose of the trademark, is to be that source identifier to generate some branding around it. So I like to recommend that a lot. And once you kind of have the set of what you're looking at for the present IP that you're licensing, then you start to think about, are we going to be licensing anything that we acquire later? As Greg will say, and Greg has talked about kind of the strategy of building a portfolio of filing continuing applications, whether that's divisionals, continuations in part, or is all that part of the package, or are you really just focused on, one branch of a portfolio, and you don't necessarily know where you're going to go or what the valuation is for later developed IP. So something you want to think about up front. Improvements, anything like that, that you want to kind of start to think about. Another thing, and lastly, kind of on this slide, another thing to think about is whether there's anything kind of coming back from the licensee, whether there's an opportunity to cross-license, whether it's present, in IP that the licensee has, or whether it's an option, whether a lot of times we put together some of the more complex deals we put together are options on what the licensee might do with licensed IP. And those can get kind of as creative as the businesses get with them, as far as, what are you talking about? An option to license, an option for equity, an option to, for first negotiation, that type of thing. So once you kind of have a sense of what the deal is about, the subject matter, the next kind of most important thing is really teasing out the license grant and what you're licensing, how you're licensing, what, the parameters, all the kind of levers and pulleys that you can kind of apply to the intellectual property that you're licensing. So it kind of starts with what rights are you licensing? That's typically what you're talking about when licensing. And you kind of start with what's the subject matter, but very quickly you're into what can you do with that subject matter. So a license is to do something. So the biggest issue here that we typically advise on, especially when you're talking about patents or know-how, is the make or the have made right. Whether you get one, just the make right, or you get both. The have made. The have made is kind of like a sub license, kind of a sub license light, where you can go out and you have the technology, you have the license, but you can go to a toller or a contract manufacturer, that kind of thing. Have that made. Your downstream partner can't really do anything other than make it for you because you hold the license. But that's an important thing to spell out in the license grant, whether you have that right or whether you're kind of on your own and you kind of have to make a go of it yourself. And then it's the typical other rights. Different intellectual property implicates different rights. So what we're talking about here is kind of patent rights, but certainly there's any number of things that you can, that's the first place we can start to carve up what you're able to do. Second big consideration, and this drives a lot of the negotiation, a lot of the value in the license is, are you talking about an exclusive license, meaning only licensee can do it to the exclusion of the licensor? Are you talking about co-exclusive where both parties can do it? Maybe there's parameters around what the licensor and the licensee can do, or a non-exclusive, which tends to be, the least valuable. An exclusive license is certainly more valuable to the licensee, generates more compensation to the licensor, but a non-exclusive license may be what all the licensee needs, and the licensor wants to license to other licensees if there's a good market for it. So that's another thing to kind of think about. And then from there, and kind of just quickly tick off, I mean, there's field restrictions you can put on, what, channels of use, where you're selling, what you're doing with it. Territory restrictions, certainly that is going to be largely informed by your kind of landscape of the intellectual property you have. Whether licensees affiliates or can affiliates have rights or can sub-license, for how many tiers they can sub-license down, whether the licensor is retaining any rights, and then whether there's any government rights. If there was government funding into the IP, there might be certain things that we need to protect for there, just to make sure that licensee knows that the government might have some conditional rights in that. So that's largely the scope of what you're talking about on the license grant. Yeah, next slide, please. So then after that, what the licensor is particularly focused on in the transaction is the compensation, and how you're going to structure the compensation coming back to the licensor for the license. And there's any number of different ways that you can kind of put this together in a commercial deal. And there's a lot of flexibility here, and I've seen a lot. We do a lot with it from our experience as far as what makes sense for the business proposition between the parties. And so just to kind of talk, a lot about kind of what's available. License fees are kind of the first thing that we talk about, because that's kind of the upfront money. Like, is there initiation fee? Is there just kind of an onboarding fee, just a, kind of an earnest money type situation where licensor is getting immediate value for putting the deal together. And then royalties is certainly the next thing that everybody's thinking about. Royalties is a good way to kind of distribute the risk of what the commercialization is going to be. So license fees tend to be pretty fixed. Some of the other items here are pretty fixed. Licensees like the idea of, I'll pay you on what I sell. And then everybody's motivated to go out and sell and actually commercialize and really do the best that they can with the IP. So some of the ways we qualify royalties are, think about different royalties, whether it's different percentages or different time periods around the different things that are being sold, licensed products, licensed services, combination products with other different things, whether there's a minimum annual royalty that the licensee has to pay and can credit against royalties actually earned. Step down is something that we have to think about. Step down is when you're licensing a patent, if the patent gets invalidated or expires, but there might still be know-how, trade secrets that are licensed. There's still value to the licensee there. You want to step down the royalty to make sure that you're not misusing your patent rights, to the extent that there's diminution in value there, but still getting value back to the licensor there. Milestone payments can address any number of different things. That's just the check that the licensor has on the licensee, making sure that the licensee is doing what it's supposed to. But these are particularly important in an exclusive license where the licensor is kind of betting on one horse with the licensee and wants to make sure that the licensee is doing all that it can to commercialize that, because that's where all the compensation, all the value for the licensor's IP is coming. So you want to make the licensor wants to make sure the licensee is doing all that. Sub-license income, how you're dividing up a sub-license tier, that kind of gets just into downstream commercial considerations. Whether the licensor is getting equity in the licensee. We typically like to talk about whether if the IP needs to be enforced and there's some kind of damages award, how we're going to treat that, how we're going to carve that up. And then assignment or organizational change fee. This is the idea that if the licensee gets bought, a bigger company, has an IPO, something like that, something that changes the licensee and kind of changes the business, the proposition, that there's some kind of fee for that as well. And then these are just a couple of things that you think about related to compensation, of course, how the licensor is going to get paid, how milestone reporting is going to go, what kind of detail you're putting into your milestone reporting. Can milestones be extended? Are they extended for a fee? If licensee's looking like it can't hit a milestone, can it pay a fee to extend? And then if it's just not hitting those milestones, ultimately licensor typically wants a right to terminate, move on, particularly in an exclusive license. But certainly you want to have that all mapped out so everybody has an understanding, and you don't get later into a licensing arrangement and then there's not a lot of detail in the agreement to guide the parties. And I just a quick kind of war story on that we deal with a lot of once license agreements are written, and typically they tend to be license agreements that we weren't involved in when they were put together. And then we have clients come to us and say, hey, can you take a look at this agreement? Here's this, very odd factual situation that's happening. And we see a lot of times where it's, the parties are not, the commercialization is not going the way that it was expected to go. Licensee has a bunch of excuses for why. They're not generating as much value for the licensor or royalties. Licensor doesn't understand. Maybe the reporting has fallen off, and so there's typically that type of thing. And then we're looking at an agreement that just doesn't have a lot of structure around it. It doesn't say what the reporting is supposed to specifically address. Parties haven't been doing it anyway. And so then you're kind of stuck in here's what the agreement says, you might not have a clear termination right, it might be just for breach, and, it's hard to prove whether the licensee's in breach. And then you're just back to a negotiation without a lot of leverage or structure. So it's a good thing to have all that. Audit rights, anti-stacking provisions, other good things to put. So I'll just kind of say, just kind of throw out here, and I'll hit the headlines here. You want to talk about prosecution, defense, and enforcement of IP assets. Make sure that you have a lot of good detail structure around that. The licensee's obligations, licensors' protections, that's typically where we earn our money as lawyers, is talking about indemnities, limitations on liability, reps and warrants, all of those types of things to make sure that the parties really have the obligations they're supposed to have. Next slide. Again, reps and warrants and indemnities, those are typically the legal terms that we get involved in and really put a lot of meat on the bones there. Next slide.
Hey, Matt, I'm going to have to call it just because we're at the next. I apologize for that. We will send the slides, and this topic's super important because so many graphene companies depend on their patent portfolios, or they've had licensed IP, like from universities, etc. So,
no, it's all right. We were at the end there anyway, so getting close to the end. So happy to field any questions that anybody has offline.
For more information on market opportunities and to connect with experts, contact the Graphene Council at thegraphenecouncil.org.